So in summary, I've really enjoyed the last 2 days because the nice thing about this conference is that we've had the opportunity to talk about the same set of issues multiple times, and each time we talk about them, something else comes out of it. So in my presentation, I'll try to avoid the things that I think by now we've talked enough about, because I'm going to really deal with what the effect is on the U.S. Patent system as far as litigation is concerned, and the disputes that arise, and maybe talk about some tricks of the trade or things that I think will happen as litigators in trying to navigate these waters, and things that I currently don't care about that you do, as far as what I do as opposed to what many of you do, but it affects all of your businesses or your clients. I'd first like to also thank Forum for partnering with us on this. This is, and the panelists and all the attendees, this has been a very fruitful discussion for me, because I've gotten insight from industry and practitioners about how they view things. And since my job is to advocate on behalf of people in court, in companies, it's very good to understand what you think and what you care about, because unless it serves a business interest, there's no reason to be doing it. In my opinion, when it comes to intellectual property. So it's been helpful. In reviewing the schedule, realizing that I was coming up here close to last, I figured that was appropriate, because probably the dispute part of it is probably what we know the least about as we're going forward. In preparing to come here, and Dr. Chambers, I'm hard to persuade to come do these things, primarily because I'll have to do a PowerPoint presentation. And I hate writing PowerPoint presentations, but I thought this one could be very easy. I could start off with 5 words. Ask me in 5 years. And that could be my entire presentation, right then and there. Because there's so much we're not going to know about this until a body of law is created around these provisions. I think Dan yesterday, his opening remark was, the more things change, the more they stay the same. And I agreed with much of his presentation and being practical about things. I think I would add to that, be careful what you ask for, because you might get it. And I think that's what you might see in patent disputes. And I think that's where we're really going to be navigating the waters. It's going to be shifting sands for us as we see how courts decide things. So I will try to go through this as quickly as possible, and we'll work under the premise that we're working with an issued patent, and what are we going to what are we going to do with it? So this is an overview of generally what I believe to be the primary issues that relate to the effects on patent disputes that arise out of the American Invents Act. In looking at joinder, I think we've discussed all of this enough as to what the purpose of joinder was to get rid of multiple defendant lawsuits. I can tell you, anecdotally, I've seen in the United States cases in which an entity has sued over 400 companies over the course of 6 days in 3 lawsuits. So the joinder issue was meant primarily, I believe, to address issues like that. They had no relationship other than the accusation of infringement related to all of them, but you could have a very small mom-and-pop store being sued at the same time with AT&T, American Express, and a shopping retail outlet. And it was getting to the point that it was happening so much, and you were having 100 defendant cases, all with different interests, and that was kind of the game as far as a lot of entities who were bringing these types of lawsuits, who were primarily these non-practicing entities, which have multiple names, and I will address at some point. But really, joinder was meant to deal with this issue, and I think we already talked about what it takes when it relates to joinder. These entities are now being sued individually. Now, one thing I think is important to keep in mind from a litigation standpoint is that defendants can waive these rights and not live and die by themselves every time. And I think you will see an evolution of consideration of that provision as to whether or not they want to be alone every time. And there are other people that impacts, and primarily those are the people that indemnify those people. Do they want to indemnify 10 lawsuits? Or would they prefer that those things be combined, such that their indemnification work on behalf of whoever their customer is or customers can be consolidated? And keep in mind that joinder relates to joinder for trial, right? So they have to file separate lawsuits, but that does not mean that those cases cannot be consolidated in district court for pretrial activities such as fact discovery, claim construction, things like that. So you're still going to see courts exercise their discretion in that regard and do that. You're also going to see defendants join those types of actions. So I would say that prior to this was really related to non-practicing entities. What you have now on every docket report every day is instead of one lawsuit with 20 defendants, you have 20 lawsuits with one defendant. It's really not changed things too much. The goal was to try to make it more expensive, this is my opinion, for non-practicing entities to have to fight multi-front wars, and therefore eventually it would be cost prohibitive, and so you'd have less lawsuits. I think the only effect I've seen is that they're exercising some discretion in where they would have sued 100 defendants at once. They're not going to file 100 lawsuits in a day because they know that some district court judge will find a way to address that issue. But they will file 10. So I think you're still going to see that. So maybe it's having a little bit of a prohibitive effect. I think overall, though, you're seeing an increase in the number of lawsuits being filed by non-practicing entities. It's just they're breaking out their defendants individually. So I would argue that really, right now, I don't think the joinder is having a real impact on litigation. But again, I think all this is going to evolve, and there's going to be a lot of strategy that comes out of this as people start to realize maybe it is better to work together under a joint defense agreement. You can still do that now, but who's going to go to trial first? Who's going to get the first claim construction ruling? Because that claim construction ruling, while not it does not have an impact on your litigation as far as you being held to that. But the bottom line is, are you going to get that judge to change his mind? No. I think that kind of speaks for itself. The congestion on the court docket, I'll give you an example of a very popular patent jurisdiction in the United States, which is the U.S. District Court for the District of Delaware. My favorite place to litigate, I think probably the best patent court, district court in the country. I was looking at some statistics the other day on one particular judge. Over the last few years, how many patent cases he had on his docket, not anything else. They have a criminal docket, they have a civil docket, they have other things to do besides patent cases. But between 2010 and 2011, the number of patent cases that he took on went from 71 to 154. And that is directly related to, I would say, primarily non-practicing entity filings. So the joinder issue, while maybe protecting certain things of 100 defendants in one lawsuit, is now doubling their docket, which they still have to treat like a patent infringement case, unless the parties settle out. There's been some discussion about how this will affect the International Trade Commission, where usually in the past, 5 years ago, only really large companies could afford to play in that forum. Now the domestic industry standard is at a point where non-practicing entities and others can get in. Some of that is actually through the evolution of some of those larger companies and how they tried to get in as foreign entities. But in any event, there's a belief, and I agree with it, that over time it will rise. Filing to the ITC will rise. Right now there's approximately 70 to 75 ITC investigations filed each year. 5 years ago, that number was 21. So they are hiring more people, coming up with new pilot programs over there to handle the congestion. I also looked at the top 10 companies in 2011 that filed patent lawsuits. And when I got into the world of patent litigation about 20 years ago, it was called the sport of kings to get involved in patent litigation. Only the really big companies that could afford it really got involved in this. In 2011, the top 10 companies that filed patent lawsuits in the United States, only one of them was not a non-practicing entity, and that was number 10, which was Novartis. Everyone else above them was some form of non-practicing entity. So that's where we're seeing the evolution of litigation, and we're also seeing the evolution of which technologies are being litigated by non-practicing entities. The one jurisdiction that's not been discussed here as it relates to joinder is the Judicial Panel for Multi-District Litigation, which is another forum where there are several lawsuits filed around the country where there are common issues by the same plaintiff. Someone can file them to have them all consolidated for pretrial purposes. That's still available. Recently, someone tried to argue that because of the American Invents Act, you couldn't do that anymore. That was just simply not true, and the panel, I think, was very quick to point that out to them. So I think joinder overall has not had a big impact, but I think the strategy around companies that are getting sued and whether they want to avail themselves of waiving that defense could change over time. I'll move through this quickly. This was a big deal for about 2 years. About 1,500 patent false marking cases were filed, primarily on patents that had expired. I represented one company that invented the BB gun back in early 1900s, had never taken off some of their original patent numbers. They were sued for patent false marking, which is considered a QTEM action that could have been brought by a private citizen on behalf of the government. They had a penalty of $500 per instance of false marking. I won't bore you with the details of how we got to where we got, but that was something that I think everyone agreed upon, that the idea that someone could just come in and sue people for marking on expired patents, that they were somehow deceiving the public and not spurring innovation was ridiculous. And so that was something that I think all parties involved in the AIA had no problems, well, I shouldn't say no problems agreeing to, but they certainly agreed it should go away. So now where it's at is the ability to bring it has been significantly narrowed. It can now be brought by a private party, but there's got to be a showing of competitive injury, and the damages are now limited to something that's adequate to compensate for the injury. I can tell you that the interesting part is that it applied to pending cases. So the day it was that President Obama signed the American Invents Act, in the cases that our firm was handling, over $1 billion of potential liability was immediately gone for our clients in one day. It destroyed an industry, a cottage industry, primarily based out of the Eastern District of Texas in a single day. That was fantastic. I had one opposing counsel that refused to agree with me that President Obama was going to sign the American Invents Act on that Friday, and it was very widely known he was, which high school he would be at, and so I took a picture that was posted, and I guess I violated copyright, and I sent it to him, and I said, can we agree now that this is over with? He took the weekend to think about it and then dismissed his case on Monday. Am I behind or in front? I went the wrong way. And as discussed earlier, virtual marking is now allowed, which I think is a very good thing. And as you can see, I think I just talked about this, had immediate impact. Prior use defense. I looked through your slides last night, and I don't disagree with anything that's on any of your slides. I think the only disagreement we have is not the value of it, but how often it will actually be used in reality. I think you should document it. I think it's something you should avail yourself of if you can, certainly. But I just don't know how much it's going to actually be used, and I really think that's kind of what it comes down to, is the percentage of use, not the value of it. I think it's a valuable defense. I really just come down to, I just don't know how often it's going to be used. And I just don't know.
I just wanted to mention that in a conversation I had with Michael Koch from Syngenta, he said to me that he's actually used it several times, but there's no record of it anywhere because it just went away. So it didn't even have to settle. I mean, there was a warning letter, and he said it gave the facts about the prior use, and it just disappeared. They never said another word. So maybe there's a kind of undercurrent that's not in the public domain. That you have to go around and maybe ask the people who have a lot of trade secrets whether whether they actually use this in response to warning letters, I don't know. But that was his experience that he told me.
Here's where I think things will evolve. If someone really wants to get you for infringement, they'll find a way. So if someone asserted, so here's the hypothetical. Someone asserts that prior use or defense against my client, and they've got it. My client is determined to stop this. Okay, well, the prior use or defense knocks out their ability to do what we've sued them for. What can they do? They can look through their portfolio to see if they have any other patents that they might not have a prior use or defense. They can exclusively license someone else's patent on another feature or something else that relates to the process that they don't have a prior use or defense on. Though they can keep coming back at you. So I believe it's a good defense. I believe it, but I believe it can be negated. I think if someone wants you bad enough as an infringer, they'll find a way, especially if they have resources to do so. I do find one thing interesting about the commercial use that can't be abandoned and must be continuous throughout the infringing process. So if you abandon it, then you kind of lose the defense. The real question then comes into what happens with improvements. And I was talking to Dr. Chambers about this. Scott and I talk about this a lot, and he said, are you not stifling what that company can do with their products? If they want to do improvements, but once they do improvements, they don't have a prior use defense for that. And so, I thought about that, and I thought, well, I think that's true. I think it depends on which industry you're in as to what the ultimate effect is on that and where you live. Best mode, I think we've covered that. My comment about best mode is I don't know how, but I believe litigators will find a way to get not necessarily the best mode defense back into litigation, but the facts of best mode back into litigation under another claim or through some other use. So I don't believe we've seen the end of that in district court litigation by any stretch of the means. I think attorneys will have to get more creative in litigation as to how they use it. So the design around, if you will. Yeah, the willfulness and advice of counsel. I don't know how much that's really been talked about so far. Now failure of an infringer to obtain advice of counsel and opinion essentially cannot be used against them to prove that they willfully infringed the patent. And really the big issue for us in litigation is that it eliminates the adverse inference that can be drawn by judges and juries previously, because that alone in front of a jury can have an impact. In other words, the way it's presented to a jury would be, did you obtain an opinion of counsel? No. Why not? It really doesn't matter what their answer is, because at the end of the day, what you're going to make the jury believe is that they didn't get an opinion of counsel because no one could give them one because they infringed my client's patent. And that's really the teeth that's been taken out of eliminating this adverse inference begins to take away part of that to erode part of that story. And I think you'll start to see jury instructions change in district court litigations about what the jury can be advised on, or what evidence can be, motions eliminated about what evidence can get into court. But that was one of the things that I thought was a positive when it comes to willfulness, because it's very seldom granted, and it's even rarely upheld at the federal circuit. Now, I do still believe people should get opinions of counsel for several reasons. One, I believe it helps in the prior user defense, and I still believe it's good corporate governance. Post-grant review. Now, this is something all of you are very interested in. I don't know that I care today, because I'm not going to deal with it for a few more years. Where I will deal with it today is advising clients for the future. Post-grant review isn't going to come into the world of district court litigation for quite some time. Which gives litigators a long time to think about how to deal with it. And during your debate today, when really prompted my question about the idea of what happens when you're dealing in an industry and Everybody knows that someone's got a patent on something that affects an industry, and how are you going to deal with that in a post-grant review, and are you going to find a way, you're always going to find a way to be able to get as much bang for the buck as you can at the patent office. But always keep yourself as many defenses and things that you can use in district court litigation if things don't go your way. And one of the things I thought about, and I'm assuming, I believe it will also evolve through procedures of the Patent Office as well as district court opinions in the Federal Circuit. I think eventually my concept of 3 people filing separate post-grant reviews, all on different claims, using different prior art. The real question is, should they have, does that mean they reasonably knew or could have raised, I'm sorry, the other claims as well, and how that's going to be handled? I have a feeling, well, that's a grandeur idea in my head. I don't know how long we'd be able to play that game if our clients wanted to. You know, there's a lot of companies that aren't interested in this type of gamesmanship in district court. But as I tell every associate that does legal research for me when I do it, they often come back and they'll say, I couldn't find any case that supports that. And I said, okay, did you find any case that says I can't do it? And really, you know, they look at me like I'm trying to do something wrong, but at the end of the day, if there's not a statute or a law that says I can't do something, then, or a local rule, or just me being smarter to know that a judge is going to crucify me for doing it, then you can do it. And then you kind of go from there. And that's often how you get your opposing counsel off guard. A lot of people are into looking into what supports my case from a legal standpoint. Well, that's good too if you got it, but if you don't have it, then the question becomes, does anything stop me from doing it? And if not, do I have a good strategy to try to pull this off? So this is where, and I will briefly comment, since while it's years away, it is an issue. It will increase the amount of stays in litigation for a period of time. I think it will follow the same path that inter-parties re-exams followed, which was in the beginning, you had an 80% chance or higher of a stay being granted on inter-parties re-exam. A stay litigation pending an outcome of an inter-parties re-exam, judges are more than happy to let the Patent Office decide that issue, and if it goes away, more power to them. Because then the district court judge gets it off his docket. They're humans. They have a docket to clear. They have work to do. Let someone else do it. However, the problem with attorneys, I think a lot of these problems are driven by attorneys, is that when we see something that works, we all start to do it. Okay, so once we started to see that work, then all of the attorneys started doing it. Okay, well then at some point the district court judge, well, wait a second. Everyone went to stay, so I mean, everything's going back in inter-parties re-exam or ex-parte re-exam, and everybody went to stay? No, and that's what happened. I mean, then you start to see it come back the other way. And I would say right now you've got a less than 50% chance of getting a stay. And I think, as Tom said earlier, it really comes down now to what stage your case is in. You know, if you try to pull this 4 months before trial, I wouldn't even file that motion. Unless I had something really, really new that I didn't know about. You do it at the beginning of your case, it's certainly not offensive, but I don't think you're going to get it as much as you used to. I know you're not, because that's not what the law does. I think over time, same thing's going to happen here. But you really won't know until you see what the burden is put on the Patent Office on post-grant reviews, because that's what drove that argument on inter-parties re-exams. Well, how many do they have? How fast are they getting out? Now, there's a mandate to get them out within a certain amount of time. But we're always going to be arguing that they're overworked, they're underpaid. We have a right to go forward with our litigation claim because our client's being harmed. And also, as a strategic standpoint, sometimes having those two things going on at the same time, if you can, is a good thing, because you can use what someone says one place and the other. And often what people are saying to the Patent Office to try to keep their claim alive in an inter-parties re-exam is exactly the stuff that we can hurt them with in district court at the very same time, if you keep those two things going together. I believe that one thing that will happen by virtue of the fact that a patentee can file a motion to lift a stay, or that a patentee can take an affirmative action to keep their case going, is you're going to see more people filing preliminary injunction motions in district court. That is extraordinary relief to ask for. They're very rarely granted. I think they will continue to be very rarely granted, even after post-grant review kicks in. But I think a lot of people are going to file them, and it is the one thing that, if I understand the rules correctly, a district court still has to address. Now, strategically, today and in 5 years, the benefit of a preliminary injunction is it makes you put, if you're the plaintiff, it makes you put the defendant, lay out their case earlier as to why I, as a plaintiff, will not succeed on the merits. So in that regard, you get them to lay out their case long before they've thought about half their case. And then a year later, they have to take a different position because of something else, a claim construction ruling. They came up with a better way to litigate their case. But you've already got them on the record saying, no, this is our position. And so, I mean, even today, that's my strategy in filing preliminary injunction motion when I can. But even if I've got the best preliminary injunction case, I give myself, at best, a 50% chance a 50% chance of actually getting it. So I do believe you'll see a lot of interplay there in district court. I believe that the district courts will follow the inter-parties re-exam wave back and forth. This is a shorter period of time back and forth. And I think it's going to take a while for all of this to evolve and then settle down. And I really think that's what's going to take a long time before you can start to tell your clients, whether you're in-house counsel or outside counsel, any level of predictability. And it may be by jurisdiction, and it may even be by court, but by judge. I certainly know that I advise my clients by judge. I'll kind of skip over some of the civil enterprise reviews. It's pretty much the same. The estoppel effect, I think, is what is very interesting on when it comes to those issues. The big thing I take away from the AIA is that we've had Congress deal with it, we've had Patent Office deal with it, we've had district court judges doing what they do every day and taking note of it but not having to deal with it. And now they're going to have to start dealing with it. What it's going to result in is a lot of different changes, a lot of different rulings in a lot of different jurisdictions. The part I like about it is that it's a new frontier at some level to try to make new arguments that you never would have thought of making earlier. And just sitting in this conference and listening to some of the speakers, I've certainly thought about new ways to skin the cat, if you will, and how to make an argument for a district court judge. Even which jurisdictions I would make those arguments in might change. I think we've kind of covered all of some of the potential litigation strategies as we've kind of gone along here. The question is whether post-grant review will be the future battleground for patent litigation, but again, if it is, it's not going to happen for quite some time. And I think Dan Nebo might have said it, and I agree. I don't necessarily think it's going to alter the amount of district court litigation significantly. I do believe where it can be used, it should be used. It's less expensive, but companies who really have significant assets at risk are always going to be looking at what happens if I don't win there, but I can still go to court. I certainly don't want to do anything to limit myself any more than humanly possible, and I think that's going to be a huge strategy going forward. And I also believe that as people have to indemnify others, I think that's going to be an issue as well. Well, I can't go that far. All right, so I did the impact of the AIA in 5 years, and looking at it last night, I realized that I didn't give any answers to any of these questions, because I'll tell you right now, I don't know that I can, but I thought it was at least, since they flew me over, I should at least give you my best guess as of today. Did Joinder, in 5 years, did Joinder reduce patent litigations filed by non-practicing entities? I believe no. Did the expansion of the prior use defense have a positive impact in some instances? Did the AIA lead to more ITC investigations? Most likely. Was the evolution of interpretation of the AIA positive or negative for litigants? I think it's going to be both. It had some positive effects, it had some negative effects. Did the post-grant review process reduce patent litigation? My answer is not by much. But then did it benefit petitioners by providing them with additional evidence to work and design around options during that period. And we'll also seeking clarity on the patent effect, their current product or process to give them more certainty in their product. Did companies properly avail themselves of the AIA provisions and more closely monitor competitors and activities at the PTO? This is where I really believe it is incumbent upon companies, their in-house counsel and their outside counsel, to do this, because this doesn't happen enough now, and this is the best chance, in my opinion, for companies to really, truly start monitoring their companies' competitors at a different level. So my answer is in the beginning, but I don't know if it'll hold. Do we have stronger patents to enforce? Absolutely. And I think that's one of the most important things that hopefully comes out of the AA. And how did the courts interpret the AA, and were the decisions consistent with the legislative intent? Got a magic 8-ball in my office. That's what I'll probably use to get you that answer. So that's anybody's guess. Is it less expensive now, 2016, than to enforce or invalidate a patent? I would say not to enforce, maybe to invalidate. So I'll end there. I was going to comment on some non-practicing entity issues just because it's been so widely discussed, and talk about some of Chief Rader's comments, because we have multiple definitions now, but I can do that in the panel discussion necessary.